Hello, I'm Michele Schuster.
And I'm Chad Blackham.
And welcome to this week's Compliance Talk. We have some exciting topics today. I mean, it's always exciting when we have legislation that's passed to talk about. That's going to be some of mine. What about you?
Well, I've got some legislation as well. We've got something out of Maryland. For those of you who were frequent viewers, you might remember from a previous Compliance Talk, our discussion of Maryland's first in its kind surveillance pricing law. So we'll be talking a little bit about that.
Very interesting.
Absolutely. And then we also, tangentially but in a similar area, have a court's enforcement of a recent FTC order against a company that violated it. Very, very pertinent for everyone watching. You want to watch out for these penalties and some of the consequences of enforcement actions.
I am quite certain that anybody watching this is not in that situation because they will not have gotten in trouble with the FTC to start with. So.
Especially if they hire us.
That's right. That's right, that's right. It's been a long month in case you guys can't tell. But it is kind of exciting, some of the things that are going on. What's exciting in Vermont is what didn't happen. And so you might remember 2 years ago, Vermont was one of the first states to introduce a privacy law that was extremely onerous. It had a private right of action. It had some very complicated things that the businesses transacting in Vermont were going to have to follow. And luckily at that point, the governor vetoed that bill. Well, it was reintroduced, and I'm happy to report that it was stripped of those provisions that we found really problematic 2 years ago. And so if you are in Vermont and you are already complying with the other state privacy laws, you're going to be taken care of in Vermont too. Probably not much to change there, but always a good idea when these bills are passed to have an attorney take a look at what you're doing for your privacy policies and how you're keeping your record retention. So just a gentle reminder, but the good news here is that Vermont walked back its previously overly onerous bill.
Absolutely. And in contrast to a state walking back its requirements, let's switch over to the enforcement of an FTC order. So back in 2015, a payment processor known as Click Inc., and there are many, many payment processors outside of the major ones, all the way down to the subsidiary level, was found by the FTC to have violated prohibitions against enacting fraud against consumers. And this took manifest in various forms, whether it be through chargeback, obfuscation, or just more clerical discrepancies. The important part here is that Click Inc. entered into an enforcement mechanism with the FTC wherein they agreed to abide by various reporting requirements, underwriting requirements, and some chargeback discrepancy analysis based on what I just mentioned. Well, unfortunately for Click Inc., a Nevada court has found that they continued to violate the consent order all the way back from 2015, and in a recent enforcement action held in the Nevada District Court has found Click Inc. liable for a $6.5 million sanction. Now, it is very significant. What's important to note here is that very often we'll see the FTC or FCC, particularly when engaging with good faith or first-time violators or good faith actors, they'll often enter into a consent order or an AVC, an assurance of voluntary consent or compliance. These agreements are typically designed to give you kind of one more bite at the apple, another chance to try and do right before more significant penalties come down, and they often have very heavy compliance reporting requirements. What we're looking at here, though, out of Nevada are the consequences of failing to abide by those orders, and it really shows the teeth that they can have. $6.5 million is nothing to sneeze at, and in addition to that, we have some kind of injunctive relief here as well, including much more enhanced reporting requirements for Click Inc. regarding their chargebacks, underwriting, a whole slew of different issues. So all of this to say that if you enter a consent decree or order with the FTC, FCC, or a state regulator like the AG, absolutely, you really need to read in between the lines because the devil is in the details, and you do not want to violate any of those provisions, or else you might be looking at a $6.5 million judgment that in some cases could reach the principles of your business. So very instructive case on something to be wary of going forward.
Yeah. I find that most of those AVCs have a provision that you have to comply with all laws.
Absolutely.
Very broad provision, something that really needs to be looked at before you execute an AVC. The other thing I would say about chargebacks, which I've always found interesting, is that the state AGs and the FTC monitor chargebacks pretty closely. They work with the payment cards to get that information. And what I think most businesses would consider a normal or acceptable chargeback rate is not what the regulators consider a normal or a relatively low chargeback rate. So anytime you get above, I would say 3%, you probably are getting onto their radar. So definitely something to monitor. If your chargebacks start getting higher as a percentage, then you probably want to take a look and see what's going on with that so that you can curtail those.
Absolutely.
All right, going back to legislation. And so Tennessee has an act that is kind of like the provision in the ABC that Chad was talking about, and it is a provision that basically anybody who is violating Tennessee's telemarketing law has got to register with the agency. And basically what it says, if you are making telephone solicitations and you don't have the proper consent or an EBR or some other type of exemption, then you must register if you make more than 500 of those calls in the state. So that means that if you're making marketing calls and you don't have the requisite consent, either that they have provided you with consent for marketing calls or for AI voice or pre-recorded message calls, not only are those a violation, but the fact that you haven't registered to let them know you have violated the law is going to be an additional violation. So it's an interesting approach, I think, to make it easier for these states to enforce the prohibition. But if you're complying with the federal laws, and that is that you have consent if you're using an artificial or pre-recorded voice, then, or if you have an EBR, so these are calls that are solicited basically, then you're not going to have to register. You're going to be in compliance anyway, and you won't need to worry about Tennessee. But I just think it's interesting and worth talking about that they kind of had these additional hooks for the non-compliant actors.
That is really fascinating. It's almost register if you're non-compliant.
Yeah, that's exactly what it is.
And it echoes shades of Wisconsin for me, where you have to register if you're conducting unsolicited telephone calls. And hopefully we won't see the degree of enforcement in Tennessee that we are seeing with Wisconsin, but that might be something to look for.
Yeah, Wisconsin is interesting, and they don't have a Attorney General's Consumer Protection section. They have the Department of Trade and Consumer Protection, or DATCP. They're in the governor's office, and they are very active, especially with issuing subpoenas. And if you do receive one of those, that is something that you do not want to ignore. You want to respond to. They're a decent agency to work with if you do work with them. So. What else have you got for us?
So I'm going to wrap us up with another piece of legislation. This one also passed into effect. So we talked a little bit about this during one of the previous Compliance Talk seminars that we had, but we have a new law coming out, and it relates to surveillance pricing. So this might be something that not a lot of people are familiar with or have an idea of what it is. But I think the best analog would be to compare this to airline pricing or Ticketmaster pricing and ticket sales. You go to the website, you get a certain price, you say, I'll think about it, you come back later, and all of a sudden that price seems to have jumped a little bit, almost as if it's watching you and knowing that you're coming back and considering it. Well, we have a new bill, HB 895, that was officially signed into law in Maryland, and this restricts the use of comparative pricing in these types of scenarios. So it has two primary prohibitions that we want to look at. The first is a prohibition on dynamic pricing. Now, dynamic pricing is what I really just referred to. This is pricing that will oscillate, go up and down based on traffic, cookie usage on websites if you're frequenting a particular website, things like that. The law also prohibits the use of personal data to conduct individualized consumer changes. So this means if you go to a grocery store and you're a frequent purchaser of a specific type of bread, they cannot use your personal data to then increase the price of that bread for you. The law also creates certain protected classes of data when it relates to data information sharing, selling, as relates to consumers' use of this type of information. But I do want to point out that there are a couple of loopholes or issues that haven't really been fully fleshed out in the law, and I think we're going to see some continuing litigation and maybe some additional legislation over. So first off, the law doesn't really establish any type of baseline pricing mechanism for saying beyond what are we looking at to determine if comparative or dynamic pricing has occurred. So we don't know what the baseline is, so there's a bit of leeway there for retailers. There's also a bit of differences in relation to the personal data provision, somewhat similar to what you were just talking about, Michelle. We have differences in the terms of dynamic pricing, which refers to a specific consumer whereas the data provisions refer to a single consumer. Now, this might seem like a small distinction, but when you have two different operative definitions in the same bill, it leads to many incongruities. And then
great litigation.
A lot of litigation, great for us.
That's right.
And then something else interesting is there's a carve out for loyalty programs or certain types of subscription programs that consumers can interact with. And this might be even extended under the current verbiage to other types of programs, not necessarily just grocery stores or physical retail locations. The law also has a very limited enforcement mechanism. It does not currently have a private right of action. Enforcement is left up to the Attorney General. But one thing I do want to note here, and that's critically important for everyone watching, is that a violation of the comparative pricing mechanism in this new law is a UDAP violation, a violation of the state's unfair, deceptive, abusive acts or practices. What this means is that a violation of this comparative pricing law, and if you offer retail goods or have a retail establishment, this is something to look at, even if it's not supermarkets or food, it extends to all types of goods. But what this means is that a violation of this law could result in relief from the Attorney General relating into enforcement, meaning heavy fines, penalties, injunctive relief, circling back to like we were saying with the ABC requirements to comply with all applicable laws. So it's a new law with limited applicability, but it might be a little broader than you initially think. So if you offer retail goods, have a retail establishment of any kind, something to be concerned or worry about. You do not want to be under the crosshairs of the Attorney General as they begin enforcement of this law.
Agreed. Okay, so wrapping up with something that I find very interesting, and this is kind of going back to the litigation mode. And so in Delaware, a court was looking at whether AI chat logs were basically discoverable, or in addition to that, if the company was required to preserve the employees' AI logs. And the court has ruled that they were required to. So to clear up the confusion here, how this applies to any of us out there that are using AI chat to come up with answers, how you are prompting that AI could become discoverable, and if there is litigation, it is definitely a piece of information that would be required to be preserved for purposes of that litigation. To give you a little bit of an understanding as to how this played out in this case, there was a corporate purchase, a purchase of a company that had occurred, and there were buyout bonuses for the employees of that company. And the purchasing company was looking to figure out a way to not buy them or not have to pay those buyouts. And so an executive had queried ChatGPT or some similar AI about if they had done these and taken a number of steps that they were outlining, would they then be outside of and not required to pay those earnouts? And so the court determined that those were discoverable, and the fact that the company had destroyed those logs meant that they were going to be sanctioned by the court. So interesting to know, something additional to think about when using AI, especially if you are entering information that is or has the potential of becoming a legal dispute. Be careful what you do, and if litigation does ensue, then you can't delete those, or you could suffer from some type of sanctions. So important stuff to know.
And just a little bit, I have some special insight into this particular case as well. It involved development of a video game in a $250 million payout, but all this is to say, at the end of the day, the video game that all these assets, all this money was put into, went to a different developer. Crafton is going to have to pay out this $250 million fine, and it really resulted in a very, very large amount of liability for them. So this AI chat log issue is definitely predominant, and we're only going to be seeing more of it in the future.
Yeah, agreed. Just the long tail that we're seeing from AI is it really does change the world and change the world that we live in. So until next time, be compliant, and we'll see you at Compliant Talks.
Okay.